Mr. Clement.
Mr. Chief Justice, and may it please the Court, this Court's cases recognize that liability for copyright infringement is not limited to direct infringers, but extends to those who induce, cause, or materially contribute to the infringement of others. And a classic form of material contribution is to provide the means of infringement to a specific known infringer, knowing that infringement is substantially certain to follow. That combination of knowledge of a specific consumer and an ongoing relationship is critical to distinguish culpable conduct from simply engaging in a one-and-done sale of an item that can be used in a way to infringe but is generally used lawfully. Now, on this record, it is beyond dispute that Cox provided the service to known infringers with substantial knowledge that what they themselves called habitual abusers would continue to infringe. That reality, along with a record chock full of Cox's admissions that it held the copyright laws and the DMCA in contempt, is what requires Cox to insist on the extreme position that they can continue to provide service to habitual abusers in perpetuity without consequences. That rule has nothing to recommend it and was admitted today would render the DMCA and the cooperation it is intended to foster a dead letter. Why bother with a safe harbor? Why worry about a limitation on liability, which is the express text of the DMCA, if there's no liability to limit? Why bother cooperating with copyright holders? Why bother having a reasonable and appropriate system for taking down repeat infringers if you're allowed to behave entirely unreasonably? So in all of this, you see that the position that's being advocated by Cox is a product of the record in this case. If Cox is right on the law, then Cox could take tens of thousands of copyright notices and throw them in the trash, and they could have its employees say, F the DMCA. That is, in fact, what the record says, which is why they're asking you for an extreme rule. I welcome the Court's questions.
How would you give or provide any contours to your approach? We know that secondary liability is atextual. Are there any limits? Justice Stevens seemed to go to great length in Sony to try to peg it to or attach it to the patent laws, patent statute. What would limit your approach?
So what would limit my approach is I would say that the provider of the service has to know that specified customers are substantially certain to infringe. And that is, to my understanding, the standard that has long prevailed in the trademark context under the Inwood case, where this court, based on a lower court opinion by Judge Friendly, that was based in part by earlier district court opinion by Judge Wazansky, which was based on the common law, says that you can have liability under the trademark laws if you either induce or you provide the means of infringement to a specific known infringer. So that is the standard, and I think if you limit it to knowledge of specific known infringers and you require, and not purpose, but intent that requires you to know that providing the service to that customer will make infringement substantially certain, I think that provides a strict limit and plenty of guidance for the lower courts.
So when we had Grokster up here, we used a much more targeted approach. I don't think, how far would Grokster get you?
Well, Grokster wouldn't get me very far in this case because this court in Grokster rested its holding on inducement. But if you look at the briefs in Grokster, if you look at the oral argument and what the lawyer for Grokster himself told this court, that was all because— That
wasn't you, was it?
It was not. It was Mr. Toronto, who's a fine federal judge now. And what Mr. Toronto told this court was that the norm of contributory liability was actually material contribution. But that wasn't an issue in the Grokster case because the Grokster technology was structured so that Grokster didn't know about the infringement of any particular customer. So that's why inducement was where this court essentially had to go in the Grokster case. But I don't think it meant to eliminate what it was told by all the parties, including the United States, and I did represent them, that material contribution was an important part of secondary copyright law.
Mr. Clement.